Hi everyone, I am Dr. Vijay Kumar Singh and welcome to the live virtual classes of Board of Studies ICAI. We are dealing with CA Intermediate and the topic is interpretation of statutes under your paper, corporate and other laws. As you would notice that this is our fourth session on this particular paper, or you can say a series of two sessions each on General Clauses Act and interpretation of statutes. So today we are having a session on interpretation of statutes. That is the second session. We have already given a introduction in our previous class and discussed a number of points, and which we will have a quick recap right now, and then we will move ahead with the remaining portions in interpretation of statutes. If you see in our previous class, we talked about this learning outcomes, and broadly we have talked about these two learning outcomes in our previous session. That is gaining knowledge about the need for interpretation of statutes. I'm sure by now you are in a situation to defend the position why we need interpretation. And second was the various rules of interpretation of statutes. That is primary rules and secondary rules. So we basically touched upon primary rules. Secondary rules today we will touch upon. And then these two other learning outcomes will be achieved today. This is what is the objective. That is particularly to focus on internal and external aids to interpretation and see how these interpretations are done. If you recollect, in our previous session, we talked about four basic principles of interpretation, and this is actually a pervasive principle which runs across, and this is very important and basic principle for everyone to know, which basically tells you as to how interpretation should flow. So you see, in interpretation, we always work or we always begin our work of interpretation by looking at the intention of the legislature, right? So what is the intention of the legislature? What intention legislature had when the law came into existence? This is one of the important elements which courts look into. Now, the question you may ask that what is this intention? How do you come to this particular intention? Definitely, intention cannot be brought forward by referring to anything else than the text of the law. So the text of the law is read, and that is where the court is trying to find out the intention of the legislature. Okay. Now, the second important point, which is there for interpretation or basic principles of interpretation, it says that you have to read the statute as a whole. So you cannot pick up one line from a statute and then interpret it in your favor or disfavor. It has to be read as a whole, and context is the king. So you have to see this in a context. What is the facts? What are the circumstances? What is the situation in which the law came into existence? If you would recollect, we talked about mischief rule. So you have to see the surrounding circumstances which actually led to the incorporation of the rule. So it is very important to look at the context. As I say always, context is the king. So here, statute must be read as a whole in the context of the things. Then the third important principle is that if the meaning is plain, effect must be given to that particular meaning, irrespective of the consequences. So while interpreting the law, you don't look for the consequences. You interpret it as per the letters of the law, as per the norms of the law. And if the meaning is plain, if the meaning is having two meanings, then you move ahead with the beneficial construction, or if it is a taxing statute, then in a strict construction, something like that. But if the meaning is plain, you don't have to go into the much details of it. Irrespective of the consequences, you have to implement it. Then the last point which comes up on the basic principle is that statute to be construed has to be made effective and workable. So there may be situations where the wordings of a statute doesn't make sense, or you can say the wordings of a statute has got ambiguous meaning. Now, in those situations, you don't just discard the statute or delete the statute. What you have to do is you have to make some sense out of that particular statute before it gets amended, right? So this situation has arisen many a times where the statute has to be made effective and workable. I can give you one example, like section 89 of the Code of Civil Procedure. So if you look at the section 89 of the Code of Civil Procedure, it was having some confusion, right, between adjudication by the courts and mediation. And court interpreted this in Salem Bar Association and subsequently in AFCON's infra. And then it provided clarity. It made the statute effective and workable by substituting the terminologies. And this was quite an interesting case to look at, that how statutes are made workable. So these are the four basic principles. Intention of the legislature. Statute must be read as a whole in the context. If meaning is plain, effect must be given to it irrespective of the consequences. And the fourth one, statute to be constituted to make it effective and workable. Now moving ahead in this particular scenario and talking about the primary and secondary rules, you would recollect that in our previous class, we discussed about rule of literal construction, which basically means that reading the statute as it is. That is word by word, line by line, and letter by letter. This is called black letter law. So we have to read the black letters as it is there. Then comes the reasonable construction, where you are trying to find out or make sense. You don't go ahead with the literal construction. You try to reason with the provision and try to go into the intention of the legislature. And that is what is reasonable construction. Then many a times two provisions may be conflicting in a statute, or maybe in a section itself, there will be two parts which are conflicting in nature. There you apply the harmonious construction. So harmonious construction is always between two different provisions in a statute, or maybe two different statutes you are trying to read together. Then you bring the harmonious construction. I have given you an example of this. Part 3 and Part 4 of the Constitution. One provides for fundamental rights. The other provides for directive principles of state policy. We try to have a harmonious construction between them, and this has been held in a number of cases. Then we studied the rule in Hayden's case, that is mischief rule. And this case, basically, we try to understand that in the laws are made to cure some mischief or cure some problem or lacunae in the law or administration. And this is referred to as mischief rule. So the rule in Hayden's case talks about mischief rule. Then there is rule of beneficial construction. So the construction can be beneficial. Specifically, we refer to Maternity Benefit Act, or maybe now the new labor codes. These are all beneficial legislations which benefit, or these are, social legislations which benefit some quarters or some part of some people. And then in these situations, you need to interpret these legislations as a beneficial or in a liberal manner. Then there is a rule of exceptional construction, and this we discussed in our class previously, that there are certain provisions where you have to create some exception, and that is what is rule of exceptional construction. What we were left in our previous class was rule of Ejusdem generis, doctrine, and the secondary rules. So this we are going to touch upon right now. Moving ahead, before we go ahead with the rules, there are certain more basic norms of interpretation. And one of them in statute, one of them in law, you will most of the times find is conjunctive and disjunctive words. So what are the conjunctive and disjunctive words? And or. So most of the times there will be a interpretation issue with this particular word, whether you have to read it as and, or you have to read it as or. So the word or is normally disjunctive, and is normally conjunctive. So wherever you will have or, you have to choose between two, and wherever there is and, you have to include both of them. But at times they are read as vice versa. This is a similar situation of may and shall. So you have to read it accordingly. So give effect to the manifest intention of the legislature as disclosed from the context. So this was held in the case of Municipal Council versus Nathumal in 1969. This is MP High Court. The expression established or incorporated. This is another example. Professor Yashpal versus State of Chhattisgarh. So here in this case, the court said the expression established or incorporated used in section 2F 22 and 23 of the University Grants Commission Act 1956 was read as established and incorporated, having regard to the constitutional scheme and in order to ensure that the act is able to achieve its objective and the UGC is able to perform its duties and responsibilities. So here you can see the act, though provided established or incorporated, the court interpreted it as established and incorporated because it cannot be established or incorporated separately. So it has to be established and incorporated. So you can see these are all draftsman error. So the court is trying to correct this and then interpret it in a way. There is another important case, Ishwar Singh Bindra and others versus State of UP, 1969. And in this case, the expression substances in the definition of drug. Drug, you all know, we are referring to drug, that is medicines. And there was a definition which used the term substances. And here in section 3b, it said means something other than medicines. And the word and used in the definition of drug in section B1 between medicines and substances is to be read disjunctively. Disjunctively means you have to read or. So it was medicines or substances. It was not medicines and substances. So in Stout's Judicial Dictionary, it is stated at page 135 that and has generally a cumulative sense, requiring the fulfillment of all the conditions that it joins together. And herein it is the antithesis of or. Sometimes, however, even in such a connection, it is by force of a contents read as or. Similarly, in maximal interpretation, it has been accepted that to carry out the intention of the legislature, it is occasionally found necessary to read the conjunctions or and one for the other. I can give you one more example, and it is quite an interesting example. And this comes from corporate law. So if you would recollect, there is something which is referred to as corporate criminal liability, right? So corporations are having a criminal liability for certain offenses. They cannot be prosecuted for rape, murder, but definitely they can be prosecuted for frauding someone or defrauding someone, right? Like corporate fraud. So the situation arose in Veliappa Textiles case, right? And there the the provision under the company under one of the provisions provided that the punishment is fine and jail, right? So the word used was fine and jail. So here, while the court were interpreting it, it said that see, it is a conjunctive word. It is not a disjunctive word. So you have to read both of them together. And in case of companies, you cannot put anybody behind bars. Hence, court held that it cannot be applied to companies. So any criminal offense wherein there was imprisonment and fine, you cannot apply that particular provision to companies. This was the interpretation which was given by Justice B. N. Sri Krishna at that point in time. However, later it was found and it was revealed that this will be a disparity, because just because the provision says and you are interpreting it, you are leaving the corporations scot-free for the crimes which has been done in the garb of the corporations by the people. So here, you cannot distinguish between a company and an individual as far as the crime is concerned, because if corporations have done the crime, then you have to punish them. So in Standard Chartered case, the courts interpreted this and as or, and it said, if it may happen that you cannot send corporations to jail or companies to jail, but definitely you can impose a penalty on them. So hence the court applied the mens rea principle there, and then they held that the companies can be held liable for mens rea offenses also, and you can impose penalty even if you are not able to send them to jail. This was further cemented in Iridium Motorola's case, and this was how you see the evolution of corporate criminal liability in the corporate law jurisprudence. So this is a very interesting case, and I would suggest you people should also read, because it relates more to the corporations and corporates. So I hope it is clear to you people, and or. So there will be situations where and will be read as or will be read as and. So you may have a question on this particular basis, and then you have to interpret whether it has to be or and. Let us move ahead. The next one, and this is mandatory and directory provisions. This, if you would recollect, we have already discussed that in General Clauses Act, may and shall. So we are repeating this again for the cost of repetition, but very important provision. This is the case of Punjab National Bank versus Ghulam Dastagir. So if you see, it is 1978 case. The statute stated that the landlord may apply to the court for eviction of the tenant in certain circumstances. Here, the Supreme Court held that in the context may imposed a duty, not a discretion on the landlord to apply for eviction under the specified circumstances. The word may was interpreted as shall, as leaving it discretionary would defeat the statute's purpose for protecting landlord rights. So it was not a situation that you say that, okay, fine, it is only saying that may apply for eviction of the tenant. Otherwise, you are competent to evict the tenant yourself. So you cannot remove the tenant without applying to the court. This is what was held in this particular case. Second important case was State of UP versus Manbodhan Lal Srivastav. And in this case, if you will see, Article 320, subclause 3, C of the Constitution stated that it shall be duty of the Union and Public Service Commission to advise on disciplinary matters. Now, the question was whether consulting the Public Service Commission was mandatory or merely directory. Since word shall is used, you can say that it is mandatory. So the court here, despite the use of the word shall, the provision was directory and not mandatory. This interpretation ensured administrative decisions were not invalidated solely due to non-compliance with the advisory requirement. So practical aspect was looked at this particular situation. Similar kind of a situation you would see in case of NCLT. So it says shall, the courts shall decide the matter in so and so days. But Supreme Court, while interpreting this provision, held that it is that shall is not mandatory, but it was directory in nature. Another case is, Lachman Narayan versus Union of India. Here, the use of the word must in place of shall will itself be sufficient for the provision to be mandatory. Yes, anybody? I think Harivansh Kumar, can you please unmute yourself? Okay, fine. So now if we look at the use of the word must in place of shall, here in Lakshmi Narayan versus Union of India, it was held that the word must in place of shall will itself be sufficient to hold the provision to be mandatory, and it will not be necessary to pursue the inquiry any further. So in certain situations, in some statutes, you will find the word must, and it will be equivalent to shall. Now, the use of word shall with respect to one matter and use of word may with respect to another matter in the same section of a statute will normally lead to the conclusion that the word shall imposes an obligation, whereas the word may confers a discretionary power. But that by itself is not decisive, and the court may, having regard to the context and consequences, come to conclusion that the part of the statute using shall is also directory. It is primarily the context in which the word are used, which will be of significance and relevance for deciding the issue. This is what G.P. Singh says. This we have already discussed in our General Clauses Act. So I'm just, doing a quick recap. So these are all modal verbs, shall and may, and they are interpreted according to the context. This is what we have discussed. These are some of the examples which are there in your, literature. So you are supposed to read them. And this is a repetition from General Clauses Act, so we are not going to go into the detail of it. Let me see if there are some. Okay. Now let us move ahead and talk about another important rule, that is the rule of Ejusdem generis, right? So the rule of Ejusdem generis is an interesting rule of interpretation, and it says, where specific words pertaining to a class or category of genus are followed by general words, the general words shall be construed as limited to the things of the same kind as those specified, right? So this rule applies when the statute contains a enumeration of specific words. So in some of the sections, you will find that there are certain things which are enumerated. And the subject of enumeration constitutes a class or category. So these subjects which are enumerated Like for example, you say, carrot, radish, or tomato. So these are all vegetables which are lined up, and if you have there something which is both in the nature of fruit and vegetable, you consider it as a vegetable. This is what the rule says. So the class or category is not exhaustive by the enumeration, and general terms follow the enumeration, and there is no indication of a different legislative intent. These are the five principles to apply rule of Ejusdem generis. Let us take an example. If the law lists automobiles like truck, tractor, motorcycle, the general term vehicles would be interpreted to mean land-based transportation and not airplanes. So you cannot include airplanes into the definition of the vehicles. So if the vehicles lists automobiles like trucks, tractors, and motorcycles, you essentially are looking at it that way, that something which is playing on the roads, not on airplanes or ships. Similarly, if the law lists dogs, cats, and other animals, the general term other animals would be interpreted to mean animals similar to dogs and cats, and not lions and tigers, right? So maybe it is referring to pets, and or not birds and fish. So this is what is the rule of Ejusdem generis. So if there are some specific enumerations, and after specific enumerations, there is a general term, then you read that particular general term as in line with the specific terms which are referred to above, not completely distinct from that. This is what is the example of Ejusdem generis. Any one of you would like to try any other example of Ejusdem generis if you have understood this principle? Yes, you can use your chat box. Ejusdem generis. Most of the times you have question on this principle. Yeah. Let us see how you craft a situation. Ejusdem generis. Go ahead. You can use the chat box. The word Ejusdem generis basically means of the same kind or nature, right? So examples I'm looking forward to, think about it and write. Yes, Ms. Tiwari, if law pertains to drugs and medicines, then how you explain Ejusdem generis? You are on right track. Use some more words, drugs and medicines, and then what else? Let me give you another example. Like, for example, we are using ban on television, microwave, mini fridge, or other large appliances. What does this means? This means basically the you are talking about large appliances and not the small appliances like coffee maker or maybe water heater, what you can say, kettle, that are not the part of it. So this is how you apply the Ejusdem generis, right? Guns and magazines. Okay. Books and stationery. Okay. So no, but books and stationery, but what is the other word? In that you have to put that. Yes. Milk, dairy product like milk, cheese, ghee, curd. And if you are saying that and others, if you write and others, then this and others has to be read with milk, ghee, cheese, curd. That should be the category. So I hope you have got this particular thing. Yes, yes, yes. Very good. Okay. So I think you have got this particular rule. Now let us move ahead and talk about another one. So these are the other, or you can say other rules of statutory interpretation. So the first one is doctrine of Noscitur is socii. Okay. So the meaning of the word is to be judged by company it keeps. So this is what is the meaning of doctrine of Noscitur is socii. And this is called by Lord Macmillan. It has said, so associated words take their meaning from one another under the doctrine of Noscitur is socii. So now if you say fresh orange juice is not a fruit juice. So here, while dealing with the Purchase Tax Act, which used the expression manufactured beverages, including fruit juices and bottled waters and syrups, it was held that the description fruit juices as occurring therein should be construed in the context of preceding words, and that orange juice, unsweetened and freshly pressed, was not within the description. Right? So this is Commissioner versus Savoy Hotel. So fresh orange juice will not be considered as a fruit juice under this, because if you see the word which is appearing along with fruit juices is manufactured beverages, including fruit juices. So it is only talking about the processed material, or it is talking about processed beverages in a factory. It is not talking about fresh juice, which is made just instantly. Okay. I hope this gives you the clarity. The meaning of a word is to be judged by the company it keeps. Let us take another example. And this is Pradeep Agarbatti versus State of Punjab. And here it said, we are in no doubt whatever that the word perfumery in the said entry number 16 draws colors from the words cosmetics and toilet goods therein. And so read the word perfumery in the said entry 16 can only refer to such articles of perfumery as are used as cosmetics and toilet goods are upon the person. The word perfumery in the context in which it is used has therefore no application to dhoop and agarbatti. So if you see, the perfumery word is used with the cosmetics and toilet goods. So this perfumery cannot be supplemented with dhoop and agarbatti. So this is what was said. So it said that the perfumery word is under the company of cosmetics and toilet goods. So that cannot be extended to dhoop and agarbatti. I hope this gives you clarity. Let us have another example. Another example is from Dr. Devendra M. Surti versus State of Gujarat. And this is where the private dispensary of a doctor is not a commercial establishment, it was held. So it said, in dealing with the definition of commercial establishment in section 2, subclause 4 of the Bombay Shops and Establishment Act, which reads, commercial establishment means establishment which carries on a business, trade, or profession. Now here the word profession was construed with the associated words business and trade, and it was held that a private dispensary of a doctor was not within the definition. So it was not a, that profession was not considered as a commercial establishment, and it was it was not held as business and trade. This also, here I would like to draw your attention. If you see the Consumer Protection Act, it defines the consumer, and it says that it does not include a consumer with the commercial purpose. So if you have a consumer who is purchasing something for commercial purpose, like say, for example, a truck owner, owns 100 trucks, or a company like, for example, Agarwal Packers and Movers owns 100 trucks, and they purchase a truck and there is some issue, they are not considered as consumer. Why? Because that is for a commercial purpose. However, if an individual has a truck and he earns his livelihood out of that, that is exempted. So this is similar kind of a logic here, if you see in this particular interpretation. Have you got, can you now on these particular examples give an example of doctrine of Noscitur socii? Yes. Yes. Go ahead. Let us have an example from you on Noscitur socii. I have given you three examples. You should now give your own examples. At least one each, everyone. Director shall not. I think, Kuldeep, this particular clause which you have referred to does not attract Ejusdem generis, because for attracting Ejusdem generis, you need to have a list of items and then followed by a general item. So, and then you have to understand the general item in line with the list of items which is provided above. That is what is Ejusdem generis. In this particular case, there are no list of items. It is the general clause which is there. Yes, try to give an example of Noscitur socii. Yes. Okay, Nagaraj. But give the other context also in this. Let me give you another example. If we say the law prohibits trash in lakes, rivers, streams, and other bodies of water. Now, since here the listed an example is natural bodies of water, the phrase other bodies of water would be interpreted to include only natural resources like sea, but will be excluding man-made ones like swimming pool. So you cannot include swimming pool into that. Okay. Let us have another example from you people on Noscitur socii. People who have responded, thank you. Okay, Steffi. Yes, but you have to see it from the perspective of context. Like there should be royalty income, etc., of authors of certain books other than text provisions. Okay, yes, very true. So here you don't include textbooks into the definition of authors of certain books. Right, very good. A nice example, Steffi. Any other example would you like to put up on this Noscitur socii? Yeah. Okay, if you don't have an example, then let me move further. Okay, you can think about the example, and if you get it, just put it in the chat box. I will repeat that. Moving ahead, we are now talking about another example, another maxim, and that is called doctrine of Contemporanea expositio, right? So this doctrine is based on the concept that a statute or a document is to be interpreted by referring to the exposition it has received from the contemporary authority. What does it mean? So it means basically that contemporaneous exposition is the best and strongest in law. This means a law should be understood in the sense in which it was understood at the time when it was passed. So the maxim optima legum interpret est consuetude means customs is the best interpreter of the law. So these are the two things. One thing is saying that you have to see the interpretation from the contemporary times. Like say, for example, there is a legislation which got incorporated in 1960s. So while interpreting the provision, you should also keep in mind that what would have been the situation in 1960s and then provide the interpretation now. Similarly, the maxim optima legum inter est constitut talks about customs is the best interpreter of law. So you also look at customs, that what is the custom which was there to interpret the law. So thus the court was influenced in its construction of a statute by Annie by the fact that it was that which has been generally considered as the true one for 160 years. This is Cox versus Slay. But remember that this maxim is to be applied for construing ancient statutes, but not to acts and contemporary or comparatively relevant, comparatively modern legislations. Okay. So this doctrine is applicable only in situations of ancient texts or ancient laws. Let us now talk about some other rules. So the one of the rules is, let me check. Okay. Yes, Ms. Tiwari, good, nice examples. Will be interpreted as road vehicles, not airplanes and ships. Okay. Yes, Nagaraj, right. Now let us look at this legal fiction, which is also referred to as deeming provisions. So, in law, we have many a times we find a fiction or deeming provisions. So legal fiction or deeming provisions is a situation where you have a deeming provision, or you try to see that a word is given a particular meaning. So there are two kinds of words, affirmative and negative words. So in the case of Ramchandra Keshav Adke versus Govind Jyoti Chavre, 1975, the statute in question imposed specific restriction on alienation of land without prior permission. Alienation of land basically is meaning creating some incumbency on the land without permission. So the provision used negative words like no transfer shall be valid unless approved by the collector. Now the court here held that the use of negative language indicated a mandatory requirement, meaning transactions without approval were null and void. Now here, affirmative language is that the application shall submit all documents by stated deadline. Now here, while shall indicates an obligation, it could be treated as directory depending on the legislative intent and context. So this is how you read affirmative and negative words. So whenever you have negative words, that indicates in all situations mandatory requirement. And if it is affirmative language, shall may be always read as may. So there is no problem there. So here, if you read another example, the tenant may install flooring, curtains, or furniture made of wood. Now here, under the rule of last antecedent. So this is another rule that is called rule of last antecedent. Made of wood would apply only to the furniture and not floorings or curtains. Now see, there can be innovative interpretation here. Somebody may say, the law says tenant may install flooring made of wood, curtain made of wood, and furniture made of wood. But here, since we apply the rule of last antecedent, the last word we associate only with the last word, not to the all other words which are following before that word. This is called rule of last antecedent. Now we are moving ahead with the aids to construction. But before we move on to the aids of construction, if there are any questions by you people, you can use the chat box for the questions. Yes. Any questions so far? Okay. No questions? Okay, let me move further. So we are talking about internal aids to interpretation or constructions first. There are two kinds of aids which are available. One is called internal aids and the other one is called external aids. So first we will talk about the internal aids. As you can see in this particular slide, which is also given in your literature, you will find that the internal aids to construction basically means the internal material which is there in the statute. So we have discussed this in our first class on General Clauses Act, the sections or parts of legislation. And in a legislation, you will find long title, preamble, heading, marginal notes, definitional sections, illustrations, proviso, explanation, schedules, and reading the statute as a whole. This is one of the principles. These are all internal aids to construction. So you will find all of these in a statute. So when you look at the statute, you will find there is a long title, there is a preamble, there is a heading, there are marginal notes. So now we will consider each of these, internal aids one by one. Let us look at the external aids before we move on to the internal aids. So there are external aids to interpretation and constructions also. So the external aids, as the name suggests, is something which is apart from the statute. So you are not only confining yourself to the statute, you are moving beyond the statute. I can give you an example. So let me show you. So this is General Clauses Act. So if I say this General Clauses Act, this anything which you are referring inside this particular book is the internal aid to construction. But to interpret this particular book, if you are going to some other literature, like say, for example, you are referring to a dictionary, then that is a external aid to construction. Say, for example, you are referring to a commentary, then that is a external aid to construction. You are referring to a judicial decision, that is a external aid to construction. Similarly, historical setting, like for example, constitution assembly debates you are referring, that is a external aid to construction. Or you are referring to similar kind of an analogous acts, that is external aid to construction. Now let me further move ahead with the internal aids to construction or interpretation. Any questions till this point? Difference between internal and external aid? Can you give an example of internal and external aids now? Yes. Judgments. Yes, judgments are external aids. Very true. Okay, now let us move ahead and talk about one by one. So what is aids to interpretation? Aids basically means assistance, support, help. So an aid is a device that helps or assists for what? For the purpose of construction or interpretation. The court has to take recourse to various internal and external aids. Internal aids means those material which are available in the statute itself, though they may not be part of the enactment. The internal aid includes long title, preamble, heading, marginal notes, illustrations, punctuations. Punctuations are even internal aids. Proviso, schedule, transitory provision, etc. When internal aids are not adequate, court has to take recourse to external aids. External aids may be parliamentary material, historical background, reports of a committee or a commission, official statements, dictionary meanings, foreign decisions, etc. Okay. In one of the Supreme Court cases, O. Chinnappa Reddy Justice said, where internal aids are not forthcoming, we can always have recourse to external aids to discover the object of the legislation. External aids are not ruled out. This is how a well-settled principle of modern statutory construction works. It is also cardinal principle or of construction that external aids are brought in by widening the concept of context, as including not only other enacting provisions of the same statute, but its preamble, the existing state of law, other statutes in pari materia. You must have heard about this particular word, pari materia. But other statutes in pari materia means basically similar kind of a statute. Okay, that will be referred to as other statutes in pari materia. Like for example, we can say that Competition Act and MRTP Act, these are the two legislations which are pari materia. They are similar kind of a statute. Similarly, we can refer to as Bharatiya Saksha Adhiniyam and Indian Evidence Act. These are pari materia statutes. And the mischief which the statute was intended to remedy, this is what Supreme Court held in District Mining Officer versus Tata Iron and Steel Limited. The legal principle pari materia, Latin for on the same subject matter. So pari materia basically stands for on the same subject matter, is used when interpreting statutes or laws that are related to each other in terms of subject, purpose, or objective. The rule suggests that laws relating or dealing with similar subjects should be interpreted harmoniously to achieve consistency. The IPC defines offenses while the CRPC lays down the procedural rules for handling offenses. Since both statutes deal with criminal law, courts often interpret provisions from these codes harmoniously under the principle of pari materia. I gave you the another examples also before. This is another example. Let us look at another case, KP Varghese versus Income Tax Officer. In this case, the Supreme Court has stated that interpretation of a statute being an exercise in the ascertainment of meaning, everything which is logically relevant should be admissible. Now we are moving ahead with the internal aids to construction. The first internal aid to construction is referred to as long title. Okay. Now when we say long title, this long title is written, you can see here in the example, Companies Act 2013. So you see the long title, an act to consolidate and amend the law relating to companies. This is a long title. And short title is the Companies Act 2013. That is a short title in red underline. So it is now settled that long title of an act is the part of the act as and admissible as an aid to construction. This is what was held in R versus Secretary of State. So the title of a statute is an important part of the act and may be referred to for the purpose of ascertaining its general scope and for throwing light on its construction, although it cannot override the clear meaning of the enactment. So this particular line, you will see many a times, okay, that it cannot override the clear meaning of the enactment. Okay. You remember the third principle, basic principle? Plain language should be given the meaning irrespective of the consequences. You remember that? So here the same thing follows throughout the interpretation. If everything is clear, you don't have to override. So none of these aids will be helpful if section is very much clear. Aids to interpretation will only be useful only when there is a confusion in interpreting the language of the provision. Like another example is Bharatiya Saksha Adhiniyam. So here long title is an act to consolidate and to provide for general rules and principles of evidence for fair trial. So you can see this particular law gives you, the long title gives you the clarity why this particular law came up. So see, there is another bill. This was by, this is called Aparajita bill. In Calcutta, this came up after that RG car incident to amend the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita and so in their application to the state of West Bengal. Though this particular law has not been yet approved, but this is how the bill came up at that point in time. Any question on this long title? Any one of you? I hope this is clear. Commentary by judge in a research paper is generally not an aid to interpretation, Kuldeep. These are not referred to by judgments or judges. You can always try to understand meaning from there, but legitimately you cannot refer to them for interpretation of the statutes. Okay, now let us move ahead because these are opinions. You cannot refer to that. Next case, Ashwini Kumar. You see this particular case? The case arose concerning the interpretation of the statutory provision related to the legal profession under the Advocates Act 1926. A dispute emerged between two categories of legal practitioners, that is, advocates who practiced in high courts and were enrolled under the Act, and the attorneys who were traditionally associated with the Supreme Court of Calcutta. So you may be aware that in the British era, there were advocates, attorneys, munsifs, there were different nomenclature. Only after the Advocates Act came up in 1965, then the legal practitioners are only referred to as advocates. So the case required Supreme Court to determine whether the term of the Advocates Act permitted advocates to appear in all courts, including Calcutta High Court. Now here the court looked at the long title while interpreting the Advocates Act 1926, and the act, the long title went like this: an act to authorize advocates of Supreme Court to practice as of right in any high court. So the court reasoned that long title underscored the intention to harmonize and systematize the rights of legal practitioner, aiming to eliminate unnecessary distinction between these different classes of practitioners. And hence it was held that all advocates are same, they can practice at all different courts. There was no exception. So I hope this application of long title in interpretation you have seen now. Okay. Now let us move ahead and talk about the next provision, that is called preamble. You all must have seen preamble of the Constitution you must have seen. So the preamble of a statute, like long title, is a part of the act and it is admissible in aid to construction. So although an enacting part, the preamble is expected to express the scope, object and purpose of the act more comprehensively than the long title. Long title is short in 1 or 2 lines. Preamble sometimes is more bigger. So the preamble to an act discloses the primary intention of the legislature, but can only be brought in as a aid to construction. Again, the same sentence. You remember, if the language of the statute is not clear. However, it cannot override the provisions of the enactment. Preamble cannot override the provisions of the enactment. Same is with the situation with long title. This is an example, which is there part of your course itself. So it says, use of the word may in section 5 of Hindu Marriage Act 1955 provides that a marriage may be solemnized between two Hindus has been constituted to be mandatory in the sense that both parties to the marriage must be Hindus as defined in section 2 of the act. It was held that the marriage between a Christian male and a Hindu female solemnized under the Hindu Marriage Act was void. This result was reached also having regard to the preamble of the act, which read an act to amend and codify the law relating to marriage among Hindus. So the law only talked about marriage among Hindus and not from other two religions. For other two religions, there is a special marriage act. So this is how preamble was utilized for interpreting this. Let me see if we have another example. Yes, we have another example. So see here, in the Karnataka Contract Carriages Act, it was to provide for the acquisition of contract carriages and for matters incidental, ancillary or subservient thereto. The preamble provided where, see, this is a very long preamble, right? You can see, so preamble can be short, preamble can be very long also. So this is a long preamble and it gives you complete detail. So you can see it says contract carriages and certain other categories of public service vehicles are being operated in the state in the manner highly detrimental, prejudicial to public interest, and there is a requirement to prevent such misuse, etc., 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 etc. So this particular law has come into picture, right? So here, in this particular case, Secretary Regional Transport, Supreme Court said, it is apparent from the preamble of the Act that the primary object of the Act is acquisition of the contract carriages with a view to prevent misuse and also to provide better facilities for the transport of passengers by the road. So I think this gives you a clarity on interpretation of the preamble. Anyone has any question till this point? Okay, let us move ahead. So you can see here, this is another example, Aprajita Women and Child West Bengal Laws Criminal Amendment Bill. So you can see the preamble, a long preamble. You can see, whereas this expedient, so and so, this is what is the preamble. This is the preamble. You can see here. Constitution of the Special Task Force, Aparajita, leave it. Preamble to the Constitution of India. So you all know preamble to the Constitution of India is utilized for interpretation. So the preamble is the part of the Constitution and enjoys the legal force. And the preamble is key to understanding the Constitution and interpreting its clauses. The preamble, together with the fundamental rights and directive principles of state policy, the most important parts of the Indian Constitution, constitute the core of the Constitution. This was held in Kishananda Bharti versus State of Kerala. For example, the Supreme Court relied on the preamble in establishing that the constitutional authorities draw their strength directly from the people of India, clarifying the character of India as a socialist republic, recognizing the possibility of the nationalization of private industries in order to secure equality and justice, and granting the expression social justice, the status of a constitutional right. These references are interpretive, yet their quantity and length indicate a more substantive role of the Indian preamble in constitutional interpretation. This is what Ramesh C. Lauti said. R.C. Lauti was the Supreme Court judge in one of his lectures, The Spirit and Backbone of Constitution of India. So you can see, so I can put one word here, that preamble to the Constitution has got more veracity in terms of preamble as an interpretation than a preamble in the statute or act. Let us move ahead. Heading. So you can see here on the right side, there are headings. Headings are like incorporation of a company, matters, incidental. These are chapter headings. So headings or titles prefixed to the section or group of sections can be referred to in the construing an act for the legislature. These are headings. The headings of different portions of a statute can be referred to determine the sense of any doubtful expression in a section ranged under a particular heading. Like for example, if I say prospectus and allotment of securities. So any section, any provision which follows between 23 to 32 are dealing with prospectus and allotment of security. So if there is any confusion, you can always see the heading, that under what heading this has been put. However, they cannot control the plain meaning of the words of the enactment, though they may in some cases be looked at in the light of the preamble if there is any ambiguity in the meaning of the sections on which they can throw light. This is another statement. Supreme Court in the case of Frick India Limited versus Union of India held it was well settled that the headings prefixed to sections or entries cannot control the plain words of the provisions. They cannot also be referred to for the purpose of construing the provisions when the words used in the provisions are clearly and unambiguous, nor can they be used for cutting down the plain meaning of the words in the provisions. Only in the case of ambiguity or doubt, the heading or subheadings may be referred to as an aid in construing the provisions, but even in such a case, it should not be used for cutting down the wide publication of the clear words used in the provisions. So you can see here, very important. In all these particular interpretation of internal aids to construction, we have very much seen that if there is a plain meaning, you cannot cut short that particular meaning by putting a reference to the aids to the construction. Marginal notes. So you see in many of the legislation, you will find the marginal notes. In this particular example on the left hand side, you see these are the marginal notes. So for section 13, facts bearing on question whether act was accidental or incidental, these are marginal notes. In section 14, existence of course of business when relevant is a marginal note. This is coming from Bharatiya Sakshya Adhiniyam as an example. So marginal notes are summaries and side notes often found at the side of a section or group of sections in an act, purporting to sum up the effect of that section or sections. They are not a part of the enactment, for they were not present when the act was passed in Parliament, but inserted after the act has been so passed. Hence, they are not an aid to the construction. Let us look at another example. In CIT versus Ahmad Bhai, Patanjali Sastri Justice, he is very celebrated judge, declared marginal notes in an Indian statute as in an act of parliament cannot be referred to for the purpose of construing a statute. So he said that this cannot be used. Many cases show that reference to marginal notes may be permissible in exceptional cases for construing a section in a statutes. However, marginal notes appended to articles of the Constitution have been held to be part of the Constitution as part of the Constituent Assembly and therefore have been used in construing the articles. Here it is interesting. I told you about, with reference to preamble also, that the valuation of preamble under the Constitution is different than valuation of a preamble in an act, right? Similarly, marginal notes of a preamble are having valuation because Constituent Assembly discussed that and that is given more precedence. And the marginal notes of an act may not be of the same level. So you can see here, this is the Constitution of India. And in that you can see the marginal notes, name and territory of the Union, admission or establishment of new states. These are all marginal notes. They have got valuation in constitutional interpretation. But in case of an act, these marginal notes may not be of very much relevance. This is another example, Bharatiya Sakshi Adhiniyam. So you can see here on the left side, there are marginal notes. In criminal cases, previous good character is relevant, evidence of character. So these are all marginal notes. This is another interesting example, and this is not with reference to marginal notes, but this is a unique example, okay? I don't know whether this is not part of your course, by the way, but for your understanding, I am putting it across. So this was one of the interesting experiment which happened in case of SEBI prohibition of insider trading regulations. So there they provided legislative notes. So the committee, I think NK Sodhi committee looked at this particular regulation and they suggested for changes. They provided legislative notes, that is further way of interpretation of the statute. So you can see here, like for example, Regulation 3, communication on procurement of unpublished price sensitive information. The provision is, subclause 1 is given there, right? So it says no insider shall communicate, provide or allow access to any unpublished price sensitive information relating to a company or securities listed or proposed to be listed to any person, including other insiders, except where such communication is in furtherance of legitimate purpose, performance of duties or discharge of legal obligation. Now this is the provision, but the law goes further and it provides notes also about it as to how you are going to interpret that. And it is saying the provision is intended to cast an obligation on all insiders who are essentially person in possession of unpublished price sensitive information to handle such information with care and to deal with the information with them when transacting their business strictly on a need to know basis. It is also intended to lead to organizations developing practices based on need to know principles for treatment of information in their possession. So you can see here how they have talked about in detail about need to know provisions, or the what you can say, it is more than the marginal notes. It is called legislative notes basically. So this you will not find in many of the legislation. I think one of the legislation was SEBI prohibition of insider trading, wherein they provided this particular explanation. I think in the new codes like Bharatiya Sakshi Adhiniyam and this, they have provided somewhere some provisions, but not in such detail. Okay. Now let us move ahead and talk about another internal aid. So you can see here, these are the legislative notes. Definitional sections or interpretation clauses. So the object of a definition, this you will find in most of the statutes, right? So the object of the definition or interpretation clause is to avoid the necessity of frequent repetitions in describing all the subject matter to which the word or expression so defined is intended to apply. The purpose of a definition clause is twofold, right? One, to provide a key to the proper interpretation of the enactment. And second is to shorten the language of the enacting part by avoiding repetition of the same words containing in the definition part every time the legislature wants to refer to the expressions contained in the definition. So you can see there are two purposes of definition. One, to provide the proper interpretation of the enactment. If you give the definition, then it is, interpretation will be better. And if you don't give the definition, every time you have to repeat the definition. And hence, at the beginning of the statute, you provide definitions of major clauses which have been used multiple times in your legislation. Like say, for example, if you see in our company law, the definition of private company, public company, promoter, relative, all these things are provided in the beginning. I think a long list of definition is there. Why? Because if they don't provide there, every time, wherever the word company comes, there has to be a meaning which has to be provided to that particular word. Company means this, public company means this. I hope this makes sense. So construction of definition may be understood under the following headings. So the definition can be restrictive and extensive, or it can be ambiguous. It can be subject to contrary context. So we will see one by one. Restrictive and extensive definitions. So the legislature has power to define a word even artificially. So legislature can define a word artificially. Like for example, section 8 of the IPC defines gender, and it says the pronoun he and its derivative are used for any person, whether male or female. So you can see the legislature says he can be used for male and female. And section 2(9) of the BNS, however, made gender the pronoun, and he says he and its derivatives are used for any person, whether male, female, or transgender. So there is a definition changed under the Bharatiya Nyaya Samhita, and they have included transgender also in this definition. Now, further, in explanation of this particular section, they define transgender shall have the meaning assigned to it under Clause K of Section 2 of Transgender Person Protection of Rights Act 2019. So the definition of a word in the definition section may either be restrictive of its ordinary meaning, or it may be extensive of the same. When a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. We must restrict the meaning of the words to that given in the definition section. However, when the word defined is there to include such and such, the definition is prima facie extensive. Here, the word defined is not restricted to the meaning assigned to it, but has extensive meaning, which also includes meaning assigned to it in a definition section. So, wherever you find the word mean, that means you have to be restrictive definition. Wherever you find the word include, that means you can include few things there. So here you apply the rule of Ejusdem generis, include, right? And you also may apply the doctrine of Noscitur sociis. We may also find a word being defined as means and includes such and such. In this case, the definition would be exhaustive. On the other hand, if the word is to define to apply to and include, the definition is understood as extensive. Now, let us look at some examples. So section so and so of the Consumer Protection Act contains an inclusive definition of person, right? And it has been held to include a company, although it is not specifically named therein. So this was in the case of Karnataka Power Transmission Corporation. So a definition section may also be worded as it deemed to include. And wherever you say deemed to include, which again is an inclusive or extensive definition, as such, words are used to bring in by a legal fiction. Sometimes something within the word defined, which according to its ordinary meaning is not included therein. So I can give you an example of Constitution. And in the Constitution, if you see Article 236 in the Constitution of India tells you that the expression district judge includes judge of the city civil court, additional district judge, joint district judge. So they have talked about many lists. So here you can include, since the word uses the include, you can have any other designation which is provided can be included here. If you see the expression of judicial service, there it is very clearly mentioned, means a service consisting exclusively of persons intended to fill the post of a district judge and other civil judicial post inferior to the post of district judge, right? So it is referring specifically to the judicial positions, not anything else. So the inclusive definition of district judge in Article 236A of the Constitution has been very widely construed to include the hierarchy of specialized civil courts like labor courts, industrial courts, which are not expressly included in the definition. This is State of Maharashtra versus Labor Practitioners Association. I think this example is clear to you. Any question till this point on mean and include? Mean and include in the definition clause. Yeah. Nothing. So let us talk about it. Next move. Ambiguous definitions. So the definitions can be ambiguous as well. Many a times you can find the definitions are ambiguous. So it is normally presumed that the legislature will be specifically precise and careful in its choice of language in a definition section. However, at times the language used in such a section itself may require interpretation. Okay. So I will give you an example, and one of the most famous example is of Industrial Disputes Act. So you see retrenchment. The definition of retrenchment, the definition says means the termination by the employer of the service of a workman for any reason whatsoever. So the word says for any reason whatsoever. Now here, what does this reason mean? It can be anything. Otherwise than a punishment inflicted by way of a disciplinary action, but does not include so and so. So it has given some exceptions. That is voluntary retirement, retirement of the workman on reaching age of superannuation, or workmen concerned certain stipulation, etc., etc. Now, 2BB that is added later says termination of service of workmen as a result of non-renewal of the contract of employment between so and so. Now, here, if you move ahead, so in this particular definition, there are first, it is talking about the reasons for any reasons whatsoever. But if you are going to interpret this term, any reasons for whatsoever, you have to go ahead and interpret the exceptions which are given under this particular section. So if you see your example 12 in your booklet, it says termination of service of a seasoned worker after the worker was over does not amount to retrenchment as per Industrial Disputes Act. Why? Because termination of the service of a workman as a result of non-renewal of contract of employment between the employer and the workman concerned on its expiry of such contract being terminated under stipulation in that behalf contained therein is an exclusion under the definition of retrenchment. So I think this is clear to you people. Any question on this particular point? Any one of you? Okay, Sayed, that's a good point. But this is an interpretation clause, so we cannot, you know, you have to read it like that sometimes. Give me a second, okay? I'll just have. Right. Okay, so let me move ahead and talk about this point. Yeah. So yes, so definitely, Steffi, here it is the reasonable construction thing will come up in this point because it is a reasonable construction, yeah, which is implied here. Okay, because here you are trying to make a sense between the provisions of the same section, and you are trying to find sense out of it. So it is a reasonable construction. Yes. Okay. Anything else till this point? Any other question you have? Okay, so I think this is the time to take a break as well. It is already 7:16, so we take a 15 minutes break. We meet at 7:35, 36. Okay. You can park your questions. If you have any questions in between, you can ask me and note it down. I will respond to them. So let us meet again at 7:36. So, Mustafa, I completely, appreciate your point which you are making regarding the understandability of interpretation of statutes by, um, generally, because it requires a lot of reading. So if you read, 2, 3 times, you will also get interpretation of a statute. So I don't think there is much challenge here. Most of the times, interpretation of a statutes is a common sense. And you concentrate, the way I have taught you is you concentrate on the four basic rules. Then you go ahead with the primary rules and then you go ahead with the secondary rules. Primary rules starting with the literal construction, then harmonious, then purposive, then harmonious, and then mischief rule. Like this, if you will study, you will be in a better position to understand the concepts. And I don't think that you will have more questions on interpretation. So including both these things, I think you will have 2 to 4 questions in your examination. That is what I could see from your previous papers. So this will be useful to you. And I think if you put a basic application, basic understanding of things, you will be in a situation to answer the questions. So I don't think there is a challenge around it. In interpretation, generally, I have seen there is no objective choice question. It is a short answer question which is there. So if you get a short answer question, you need to explain that part. So I will touch upon a couple of them questions if it is possible today. Otherwise, in your revision classes. But see here is that you read it, again and again, right? That is very important. Yes, yes, definitely, definitely. It is more logical. So if you apply the law in a general sense, if you try to read that, it will be automatically clear to you that you know what it means. So that is the point. But like for example, there are two maxims, right? Contemporanea, expositio, or you say in Ejusdem generis or Noscitur socii. So you need to understand a basic meaning of it and one example. So that much is sufficient for you people. So there are not many of them which is given to you. So that is very, very, easier for you to understand. Just imagine in the law school, we give, there is a whole subject of legal method where students are supposed to read 50, 55 maxims and remember them. And they have to apply that. So that is legal on a, pure legal side. But here you need to understand some basic requirement. And these are meant from CA perspective. Like say, for example, Ejusdem generis and Noscitur socii, most of the times these maxims you will be utilizing because you will be dealing with GST, you will be dealing with customs or any taxation matters. In all these, you will find that there will be list of items which are taxable, non-taxable, and you have to interpret that by applying these principles. Hence, these are important portions in the ICAI syllabus. And I think that is with a lot of consideration that the ICAI has, drafted this particular syllabus. Yes, 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 Ranu, you're right. So if you are learning it with a practical example, then that will be more easier for you to learn. The principle is more easier to be learned. Yes. Yes, pronunciation also is a very important thing. And if you pronounce 2, 3 times, you will come to get the pronunciation. Okay. So it is not a very difficult task. If you read it again and again, then you will come to, pronounce it. Because some terms I understand is for the first time you are reading. So definitely there will be difficulty in pronunciation. But you should not deter from that because your language improves. Because when you will become a chartered accountant, then you have to deal with these particular things. And if you start early, like from now on, if you are reading it again and again, it will come within your language. So then it will not be very cumbersome to you. Right now, since it is new to you, it is cumbersome. But once you are familiar with it, reading it again and again, it will become familiar to you and then not very cumbersome to you. And that will come automatically. Okay, let us now move ahead and talk about the other important internal aids, which we are going to discuss further. And let us move further and talk about the another part, that is definition subject to contrary context, right? So here, when a word has been defined in the interpretation clause, prima facie, that definition governs whenever that word is used in the body of the statute. So wherever you find a word in the statute, if there is a definition given of that particular word, you need to follow that particular definition again and again. You cannot change that particular definition. Like, for example, in this particular case, the question was with reference to definition of insurer, right? As you can see in this particular case of the Vanguard Fire and General Insurance Company versus Fraser and Ross and another company. So here the question was relating to interpretation of the term insurer. And here the court said, if you see here, if you read it, it said a perusal of few sections of the act will illustrate this and immediately show that the word insurer has been used in some sections to mean not merely a person actually carrying on the business of insurance, but also a person who intended to carry on the business of insurance, but has not actually started it, and also a person who was carrying on the business of insurance, but has ceased to do so. For example, section 3.2, which deals with an application of registration. So this is how they have tried to explain the meaning of insurance. There are some of the another important internal aids to construction is illustrations. So in many of the legislations, you find illustrations. Like, for example, you will find illustration in Contract Act. There you will find illustration. I have given you an example of illustration in Bharatiya Sakshi Adhiniyam. So this is Evidence Act. So illustrations appended to a section forms a part of a statute, and although forming no part of the section are of relevance. Now, one of you have commented that, it appears I am reading the text. So this is, I am doing it because you need to also get the habit of reading it, because unless you read that fully, you will not be able to understand what I mean to say. I can give you the explanation without reading them, but I'm deliberately reading it because if I read it, then it goes into your ears and you are also simultaneously reading it. So this you will internalize and it will become easier for you to understand interpretation. So that is why I am doing that. So see what we are saying here. Illustrations appended to a section form part of the statute, and although forming no part of the section are of relevance and value in construction of the text of the section, and they should not be readily rejected as repugnant to the section. This is what it is saying. However, they cannot have the effect of modifying the language of the section, and they cannot either curtail or expand the ambit of the section, which alone forms the enactment, right? So you can see here, illustrations cannot change the meaning of the section. They can only assist in interpreting the terms. Like, for example, in Bharatiya Sakshi Adhiniyam, the definition of closely connected facts gives you few examples, like the illustrations. These illustrations explain the situation of the section. Like, if you see in subclause A, it says A is accused of murder of B by beating him. Whatever was said by or done by A or B or by the bystanders at the beating, or so shortly before or after that, is forming the part of the transaction, and it is a relevant fact. This is called chain of actions. So basically, that is a connected fact. I hope you understood the illustration part of it. These are another example of Indian Contract Act. So you can see it is talking about communication. So communication of a proposal is complete. When it is complete, there is a section which talks about it. And then there is an example, like A proposes by letter to sell a house to B at a certain price. The communication of the proposal is complete when B receives the letter. This is what are the illustrations. So these are different illustrations given, and above the section is there. So illustration assists in interpretation of the provision. This is another example, and you can see here, this is Juma Masjid case. And if you see here, there is an illustration appended to section 43 of the Transfer of Property Act. And we have deferred consideration thereof to the last, as there have been controversy as to how far it is admissible to construing this section as follows. The court has said that how far we can utilize the illustration for interpretation. So they have read the illustration and then say, in this illustration, when A sold the field to Z or C, he had only a spes successionis, but he having subsequently inherited it, become entitled to it. This would appear to conclude that question against the appellant. But it is argued that the illustration is repugnant to the section and must be rejected. So here you see in this particular case, illustration was going contrary to the provisions of the law. So it was not, assisting in the interpretation of the provision, and hence it was rejected. So in this particular case, they have rejected the illustration. They have not been guided by the illustration. So it is, you can see it will depend on the court that whether they will take illustration as an example or will be guiding the provision. So illustrations cannot guide the provisions. They cannot change the meaning of the provisions. They can only assist in interpreting that. Now let us move ahead and talk about this case again. Went further, and I will not go into the much of these details, but here the court's observation about the duty of the court is important, and it says it is the duty of the court of law to accept, if that can be done, the illustrations given as being both of relevance and value in the construction of the text. The illustrations should in no case be rejected because they do not square with the ideas possibly derived from the other systems of jurisprudence as to the law which they are the sections deal, and it would therefore require a very special case to warrant their rejection. So basically these arguments are by the courts that whether the illustration can be rejected or it can be accepted. So it will depend on the context of the case that whether the court is accepting the. So there is a not very clarity, as you saw in case of preamble, in case of definition, that they can be utilized as an internal aid. In case of illustrations, illustration is not a very strong internal aid for construction. So you cannot change the meaning of the provision with reference to illustrations. Now let us talk about proviso. So this is very important, okay? Proviso. So most of these sections will have a proviso, and the proviso will be funded like this. So as you can see in this section on Bharatiya Sakshya Adhiniyam, provided that this is the proviso. So what does the proviso mean? Proviso basically means it is an kind of an exception. So whatever is written above the proviso, proviso is the exception to whatever is written above the proviso. And in a section, there can be more than one proviso, and you can see how it is written. So there is first one is provided that, then second one is provided further that. Like this, the provisos can be there. In a section, there can be 3 or 4 provisos. It doesn't matter. So the normal function of a proviso is to accept something, as I told you, out of the enactment, or to qualify something stated in the enactment, which would be within its purview if the proviso were not there. So usually a proviso is embedded in the main body of the section and becomes as an integral part of it. Provisos that are so included begin with the words provided that. So proviso is a very strong aid of construction. In fact, you can say this is part of the section. So proviso has to be read along with the section. It is not a kind of an aid. It is part of the section. But proviso, you should understand what is proviso. Then the effect of the proviso is to qualify the preceding enactment, which is expressed in terms which are too general. So as a general rule, a proviso is added to an enactment to qualify or create an exception to what is in the enactment. Ordinarily, a proviso is not interpreted as stating a general rule. So proviso does not state a general rule. In this particular section, you can see section 55, the general rule is given in 1 to 4. But what proviso gives is an exception. I hope you understand this term proviso. Now there are proviso, exception, and saving clause. These are the 3 different terms which are there in the statutes, and you should know the distinction between it as per your course plan. So if you see, exception clauses are intended to restrain the enacting clause to a particular cases, whereas saving clauses is used to preserve from destruction of certain rights, remedies, or privileges already existing. And proviso, I have already told you, it is an exception to restrain the acting clause of a particular case. So in Ram Narayan Sons versus Assistant Commissioner, the court laid down the cardinal rule of interpretation that a proviso or exception to a particular provision of a statute only embraces the field which is covered by the main provision, whereas it carves out an exception to the main provision to which it has been enacted as a proviso and to no other. So if you see in the previous section, the proviso here will not affect any other section than 55, right? So these two provisos will be only with reference to section 55, not to section 54 or any other provision. Whereas when I say the saving clause applies to everything probably here and this is towards the end of the section. So you can see here, again, let us have a look at the example aspects, different aspects of proviso, exception, and saving clause. So purpose of proviso is to limit or qualify the main provision, whereas purpose of exception is to remove a particular case from the main provision. And saving clause basically preserves the right or effect of repealed law. The scope of proviso is, to operate in the general rule, whereas in case of saving clause, it protects certain situations from change. And the effect of these provisions are a bit different. So you can see the effect of proviso is to create a condition or limitation, whereas exception is to make exclusion of the case as applicable, and saving clause to ensure legal continuity. Now, these are some of the examples. Like for example, in Transfer of Property Act, there is a proviso, and here the proviso limits the applicability of general rule by creating a specific exception to the transfer under the Hindu Succession Act. Whereas in case of murder, there are exceptions. So these are exceptions which can be taken as an excuse of doing a murder, or you can say homicide. And in saving clause, you can see section 6 of the General Clauses Act, where they are talking about the saving clause, which ensures that the previously existing rights and liabilities are unaffected by the repeal. So this is the difference between these three provisions. I think somebody raised the hand. If you want to speak, you can speak. Unmute yourself and speak. I hope you have that power. Just a second. Let me find out. Anyone? You can use the chat box also. It is convenient to look at the chat box. Yeah. Okay, Kuldeep. Thank you. Now let us move ahead and talk about the another part, that is explanation. So in statutes, you will also find the explanation. So explanation is basically used in the statute to explain the meaning of certain words or phrases used in that section, or of the purport of the section. An explanation may be added to include something within the section or exclude something from the section. That is what is the objective of explanation. Here in this section, you can see explanation is there. 3 explanations are there for primary evidence. Okay. And if you see the definition of a primary evidence, what it says, primary evidence means document itself produced for the inspection of the court. Now here, explanation explains further. Like for example, where a document is executed in several parts, each part is a primary evidence of the document. So this is a further explanation. Here on the top, can you identify there is a red thing on the top? What is that? Which you can find there. The red square just after the chapter. What is that called? Yes. No, it is not short title. Short title is at the beginning of the statute. When you begin with the statute, before the preamble is the long title, and after the preamble in the section 1, there is a short title. This is chapter 5, so short title will not come here. Aslesha. Yes. Title, no. Yes. Anybody else? Heading. Mustafa, very good. It is heading. Okay. Another question which I will ask you is, what is this called? Another square or rectangle rather. Marginal note. Very good, Mustafa. So this is a marginal note. And can we use them for interpretation as an internal aid? Yes. Yes. Yes, we can, but they cannot change the meaning of the section, right? Any of these interpretation internal aids cannot change the meaning of the section. Okay, very good. Now let us move ahead and talk about another important judgment. This is Sundar Ram Pillai versus Patiba Raman, Fazal Ali Justice. talked about the objects of explanation to a statutory provision. I think this is part of your syllabus, a part of your course material. Okay. So you can see here, in this case, the court has basically talked about the objective of explanation section, and it said explanation section is there to explain the meaning and intendment of the act itself, clarify any obscurity and vagueness, if any, in the main enactment to make it consistent with the object, provide an additional support to the object of the act to make it meaningful and purposeful, fill up the gap which is relevant for the purpose of the explanation to suppress the mischief and advance the object of the act. And it cannot take away a statutory right. So this is what has been said by Fazal Ali Justice, one of the important justices who gave the decision initial days, and he has clarified this in one of the cases. Now let me take you further. Then in the act you will also find schedules. So schedules are basically different schedules are there. So schedules forms part of the act. Therefore, they must be read together with the act for all purposes of construction. However, the expressions in schedule cannot control or prevail over the expressions in the enactment. So if there appears to be any inconsistency between the schedule and the enactment will always prevail. Like for example, here you see schedule 1, it is talking about table A. Here on the bracket you refer section 4 and 5. So this schedule is subject to section 4 or 5. So if you find something which is inconsistent here in the schedule with provisions of section 4 and 5, always provisions of section 4 and 5 will have precedence over the table. I hope this is clear to you. So you can see here different schedules under the Companies Act, schedule 1 to 1, there are different tables. So these are the schedules under the Companies Act. I hope this is clear to you. Let us now move to punctuations. Punctuations are very interesting ones. So in punctuation is very important. This is an additional material. This is not part of your syllabus. So if you see, punctuation is important in interpreting statutes because it can help clarify the meaning of a statute and resolve ambiguities. Punctuation marks like comma, semicolon, colon, and dashes can help identify the structure of a statute. The orthodox view of the earlier English judges was that punctuation formed no part of the statute. Appears quite clearly from the observation of one of the judges, that is Willis Justice, in one of the cases. However, later on, the punctuations have been very importantly looked at it. So if punctuations is without sense or conflicts with the plain meaning of the words, the court will not allow it to be cause a meaning to be placed upon the words which they otherwise would not have. However, in India, if you see interpretation by the courts have used punctuations to interpret the provisions. So in one of the literature, Horton Moore observes that it is curious paradox that judges whose entire reading is punctuated should, in carefully punctuated judgments, consider themselves obliged to proclaim that punctuation is carefully punctuated statutes is in no part of the law. So you can see this is a quite of a verbose. So I'm not going into the detail of it. This is an additional material. You can read it and try to make sense out of it. Let us now talk about another important aspect, which says statute must be read as a whole in its context. This we have already seen that as one of the principles before. So it is the elementary principle that construction of a statute is to make of all its parts taken together and not of one part only. The deed must be read as a whole in order to ascertain the true meaning of its several clauses, and the words of each clause should be so interpreted as to bring them into harmony with other provisions. If that interpretation does no violence to the meaning of which they are naturally susceptible, and the same approach would apply with equal force with regard to acts and rules passed by the legislature. This rule you must have seen, that definition of law under Article 13. So everything, whatever is included, rules and regulations, acts are on the same pedestal as far as interpretation is concerned. So there is an example in your literature. If you go through that, yes, that is a comma case. Mustafa, we will talk about it in a while. I will tell you about that. So example 14, if one section of an act requires notice, should be given then a verbal notice would generally be sufficient. But if another section provides that notice should be served on the person or left with him on a particular manner or place, then it would be obviously indicate that the written notice was intended. So this is, you have to read both the provisions together to make sense of the law. Now we are moving to the external aids to interpretation or construction. So before we move to the external aids to the interpretation or constructions, you were talking about comma case. So did you find any, could you find that particular case, comma case? Yes. Yes, go ahead from comma case. Yes, it is Rogers versus Alliot, and a very interesting case. So for particularly for contract drafting, this is a very important case because if you miss that tiny details, sometimes it can cost you millions. This is what is talked about that. I hope you got a chance to read that. If you cannot, then please read it. Okay. Yes, comma creates a confusion about the termination of the contract. True. Okay, very good. So you have put your effort there. I appreciate that. Now let us move ahead and talk about this external aids to construction. So when internal aids are not adequate, so you move to the external aids to construction. Not in all cases, only when your internal aids are not helping you, you move ahead with external aids. And they are very useful tools for construction of the statutory provisions. So as opposed to internal aids to construction, there can be certain aids which are external to the statutes. This we have seen that already. Let us move ahead with one by one. First one is historical settings. So historical settings of a statute means basically these are history of external circumstances which led to the enactment of the law in question. Okay. And if you read this history, you come to know a lot about the statute. So we have for this purpose to take help from all those external or historical facts which are necessary in understanding the comprehension of the subject matter. So history generally will include parliamentary history, will include any commission which has been appointed. Like say, for example, in Companies Act, if you are interpreting 2013, J.J. Irani Committee report will be very relevant. If you are reading IBC, Insolvency Bankruptcy Code, E.K. Vishwanathan Committee report will be very helpful. If you are reading Constitution, then Constitution and Assembly debates may be helpful as an external aid to construction. So we have to consider whether the statute in question was intended to alter the law. So you can, I can give you many more examples, which gives you, so historical setting gives you the background. Like for example, if you see Competition Act, so there the historical background of the competition law was traced in CCI versus Sale by Supreme Court to elaborate why this particular law came into existence. Similarly, if you will see Consumer Protection Act, initial Supreme Court decisions, they also trace the history of Consumer Protection Act, why the Consumer Protection Act came into picture. Similarly, if you see the mediation or alternate dispute resolution, the courts have looked at the history, why these particular laws have come up. So these are external aid to construction to provide more weightage to the interpretation. consolidating statutes and previous laws. So many a times consolidating statutes and previous laws are also a very important aid to interpretation. Like a consolidating statute brings together the provisions of several earlier statutes on the same subject. And here you can go to the older statutes to look at the structure and language, or to refer to the earlier enactments for clearing your ambiguities or determining what the consolidating statute is seeking to do. Like, for example, if you want to understand the meaning of inability to pay debt, probably you will go to the provisions of inability to pay debt under the Companies Act 1956, though now the provision is no more there, but still for interpretation, for understanding, you can go there. Similarly, if you see Companies Act 2013 replaced several provisions of the Companies Act 1956, and it came up with Serious Fraud Investigation Office under Section 212, which incorporated elements previously scattered across older laws, allowing courts to draw parallel distinctions. So if you see previous laws can also be an important interpretation tool. So judicial interpretation often involves examining earlier laws. Example could be General Clauses Act 1897 is frequently referred for interpreting terms in statutes that succeeded earlier law. Like if you have to refer to, like in one of the landmark cases, Bengal Immunity Company versus State of Bihar, for interpreting the term sale of goods, they refer to the earlier, pre-constitutional tax laws. So these are the, provisions which can be looked at for as an external aid. Usage. Many a times usage, or you can say customs, are utilized as an external aid. So usage is also sometimes taken into consideration for construing the act. Like the acts done under a statute provide quite often the key to the statute itself. It is well known that where the meaning of a language in a statute is doubtful, usage, how that language has been interpreted and acted upon over a long period, may determine its true meaning. So it has been emphasized that when a legislative measure of doubtful meaning has for several years received an interpretation which has generally been acted upon, so you will be looking at that meaning. Like, for example, in taxation matters or in customs issues, what you look at meaning of a term, like for example, under the mercantile customs or traditions, if a particular word or if a particular term has got a particular meaning, you follow that meaning, right? So that is by way of a usage. So I can give you an example. Income Tax Act of India includes several terms that may be subject to interpretation, such as income, capital asset. So in one of the cases, CIT versus Taj Mahal Hotel, the Supreme Court of India dealt with the interpretation of the term plant. So there is a term called plant under the Income Tax Act. And the question arose in this particular case, whether the items like furniture, fittings in a hotel qualified as a plant, So there is quite an interesting one. So somebody said that, okay, fine, this is an industry. So for hotel, what could be the plant? There cannot be machinery. So you treat this particular table and the chairs and everything as plants. So the court relied on the usage in the hospitality industry, where furniture and fittings were recognized as an integral to the operation of the hotel. Based on this understanding, the court held that such items fell within the meaning of the plant. See, quite an interesting definition, right? If somebody would ask you that whether the table and chairs and beds in the hotel are plant or not, probably you would say that no. But see, in this particular case, the court said that giving the nature of the industry, it is a plant, which could qualify for depreciation under the Act. This shows how court use established practices and industry-specific meanings to resolve statutory ambiguities. Quite an interesting example. If you are aware about any of the other examples, please, feel free to write it in your chat box. Let us move ahead. Earlier and later acts and analogous acts. So you also look at the previous laws. Like, for example, if you are interpreting Companies Act 2013, you will be definitely going back to the laws like Companies Act 1956, or laws which are much prior to that particular law is also something you will be looking at. Give me a second. Yes. So that is there. Now, let us look at it. The general principle is that where there are different statutes in pari materia, that is analogous case. Here, at different times, even if the law has expired, you look at that particular law for interpretational purposes. I think this is self-sufficient. I will not go much into the details of this. So where single section of one act is incorporated into another statute, say Act B, it may be read in the sense that it bore the original act. So I have given you the example on this. Let us look at this. This is earlier act explained by the later act. So not only may the later act be construed in the light of the earlier act, but sometimes furnishes a legislative interpretation of the earlier one if it is pari materia. Pari materia meaning I have told you. What do you mean by pari materia? Any one of you can put example pari materia. I disagree with you, Mustafa, that law never been in emotion or assumptions. Law is most of the times in emotions and assumptions, particularly if you talk about the public law. But unfortunately, when you are talking about private law, particularly the commercial law, it is without emotions. Yes. So that has to be because it is talking about money and it is talking about monetary things, taxation. So these cannot have emotions. It has to be concrete terms. But when you talk about public law, like rights, duties, and fundamental rights, there is a lot of emotions. If you see, the courts have been exponentially creative, which I say judicial activism, where they have expanded the meanings by way of emotions itself. Like, for example, Article 21 of the Constitution of India says no person shall be deprived of the personal life and liberty except according to the procedure established by law. This is just one line article. And you see there are so many rights incorporated or brought under that provision. So we cannot say that law is emotionless. Law is definitely having a lot of emotion. Thank you. Pari materia is equal to same subject or the matter. Thank you, all of you. Now let me move ahead and talk about where the earlier statute contained a negative provisions, but the later one merely omits that negative provisions. This cannot by itself result in substantive affirmation. In such a situation, it would be necessary to see how the law would have stood without the original provisions and the terms in which the repealed sections are reenacted. So reference to repealed act, you remember section 6 of the General Clauses Act. So where an act has been repealed, it loses its operative force, but still the repealed part of the act may be taken into account given its interpretation or its history, which has been already interpreted. Now there are definitions and dictionaries. So many of the definitions in dictionaries you will find, first we have to refer to the act in question to find out if any particular word or expression is defined. So most of the times you refer to dictionaries. It can be legal dictionary, it can be Black's Law dictionary, it can be common dictionary. So wherever you find some confusion, you go to the legal dictionary, but it is an external aid to construction. In many of the court decision, you will find they have referred to Black's Law dictionary for understanding a meaning. And you have to see it because it is a fundamental rule that meaning of words and expression used in an act must take their color from the context in which they appear. So meaning given in a dictionary may not have that context. So you have to see it from the perspective of the context. So all dictionary meanings cannot be imported into the interpretation. If they have to come up with a definition, if they have to understand one term, probably they will refer to different dictionaries and come to an interpretation on the basis of the context. However, dictionaries are used as a external aid to constructions, but not very often. Okay. Now, use of foreign decisions. So use of foreign decisions are part of in our country, we have been referring to that in many of the cases. Like, for example, in Keshavananda Bharti case, the Supreme Court referred to the decisions of United Kingdom, United States, Australia, while articulating the basic structure doctrine. Similarly, in Vishaka versus State of Rajasthan, it looked at CEDAW Convention and it laid down the guidelines. And many other decisions, like, for example, I am remembering NCLAT referred to a Singapore decision while deciding on a cross-border insolvency. So like this, we have been referring to foreign court decisions as an external aid to construction. However, for your information, the Indian courts are not bound by the decisions of the foreign court. So they have to, these are persuasive decisions, so not binding. And you have to see it from, as per the context. So they have to be context specific and context sensitive. And this is always subordinate to domestic law. So if there is an Indian decision by a high court that is having more weightage than a Supreme Court US decision, US Supreme Court decision will have less weightage than the decision which has been given by our lower courts even, or the courts, any of the Indian courts. I hope this gives you clarity. Now let us move ahead and talks about the another section of the part. So this concludes our interpretation or external aids to construction. Now we are moving ahead with interpretation of construction and deeds and documents. So when we talk about construction of deeds and documents, you have to always remember that whenever you are construing a contract or any deed or document, the first and foremost point which you have to keep in mind is that you have to find out what is reasonable man would be thinking while reading that document. So you don't have to be, super man to read a deed or a document. You have to apply the common man standard. Common man is a very important thing. Okay. You remember the R.K. Lakshman cartoon of Common Man? So that common man we are talking about, which you can understand, which has a normal understanding. So you have to inform yourself with the surrounding circumstances of the deeds and documents and understand the words used in that deed and document in its context. So the principle of construction in case of documents and a deed does not differ so much than a statutory interpretation. A deed must be read as a whole. These are basic principles in order to ascertain the true meaning of its several clauses. And the words of each clause should be so interpreted so as to bring them in harmony with. So Lord Watson has said this. So while doing the interpretation of deeds, documents, you have to do a harmonious construction. Then in all cases, endeavor shall be made to find out how a reasonable and well-informed person would be understanding those words in the deeds and documents. So the golden rule of construction is to ascertain the intention of the parties to the instrument after considering all the words in their ordinary and natural sense. To ascertain this intention, the court has to consider the relevant portion of the document as a whole and also to take into account and circumstances under which the particular words were used. Very often, the status and the training of the parties using the words have to be taken into consideration. Like say, for example, two lawyers enter into a contract would be interpreted in a different way than a lawyer and an old lady who doesn't know how to read and write will be interpreted in a different word, right? So say, for example, a contract with a Pardanashi lady will be referred to or read with in a different word. So please try to understand the context of the document. Like, for example, a contract between an employer and an employee will always be read in a different way because employee will always have a leverage over that particular contract. So try to see it from that particular perspective. Here, I would also like to put one important term that contracts nowadays provide for dispute resolution clauses, right? And most of the time it talks about arbitration, that refer the dispute to arbitration. So in many of the contracts, wherever dispute arises, the first thing which comes for interpretation before the court is the document. And they want to interpret that whether there was an arbitration clause, whether the dispute was to be handled by arbitration or not. And this is the first thing which happens in arbitration. So this is very important provision, actually, interpretation of documents and deeds. So this is what I wanted to say here. Now let me talk about another thing. Okay, but before I move, let me take up any questions you have. Okay, so yes. So basically, in IOS have two types of factors. So these are not called factors, Mustafa. These are aids to interpretation. Okay, AID, aids to interpretation. So there are internal aids to interpretation and external aid to interpretation. Yes, Kuldeep, you are right. employee will always be looked as oppressed. But scenario has changed nowadays. But still, similar was the situation with tenant and landlord. So always tenant was considered to be oppressed in the initial day. You will see tenancy laws were meant for that. But nowadays, I think things have changed now. So this is how the law is interpreted. Okay. Now I will give you some situations and you have to contemplate what would be the answer. Here you can use your mic. All of you, if you want to speak, please raise your hand and then your mic will be enabled and then you can speak on this particular term. This is how the questions will be asked in your examination. Okay. What is that? It is to be borne in mind. Okay, this is about the interpretation of the law itself. So you can see here interpretation of deed. Well, I'm completing that first. So these are some of the case laws. So it is elementary rule of construction that same word cannot have two different meanings. The document must be read as a whole. These are the same principles. It may also happen that there is a conflict between two or more clauses of the same document. An effort must be made to resolve the conflict. So the four basic principles of interpretation which I gave you in the beginning is going to the same, except in place of intention of the legislature, you look at the intention of the parties in case of documents, right? The rest of the things remain same. So similarly, one part of the document is in conflict. You look at the other part of the document and try to harmoniously work out. There is a doctrine which is called doctrine of severability. So you sever the unapplicable part of the document and apply the remaining part of the document. I think you people must have studied that in contract. These are some of the references which I have used while preparing the slides. And if you want to read more on interpretation, you can purchase one of the books. I would recommend GP Singh for you, or if you want a student edition, you can go for BM Gandhi as well. This is a question. Can you put some answers here? At the time of interpreting a statute, what will be the effect of usage or custom and practices? Yes. Yeah, Keshavananda Bharati case is talked about for multiple reasons. So one of the main reasons is that it is a 13 bench decision. So it is one of the largest bench and one decision and one of its kind. Secondly, in this particular case, the court laid down the basic feature of the constitution and said that because court was interpreting the amending power of the parliament and said that though constitution provides for amending power to the parliament, it cannot amend everything under the constitution. There are certain things which cannot be amended, like basic feature of separation of judiciary and executive and legislature. This cannot be amended. Preamble cannot be amended. Fundamental rights which is given to the people, that cannot be amended. Certain things which has been talked about and it has been said that that cannot be amended. Right? Okay. Yes. So you see, if this is the question which may be asked to you in your exam. So if it is asked, then it is expected that you write something like this. So you can see effect of usage. Usage or practice developed under the statute is indicative of the meaning recognized to its word by contemporary opinion. A uniform, notorious practice continued under old statute and inaction of the legislature to amend the same are important factors to show that the practice so followed was based on correct understanding of law. When the usage or practice receives judicial or legislative approval, it gains additional weight. In this connection, we have to bear in mind two Latin maxims. One is optima legum interpres est constitude. This we talked about it. The custom is the best interpreter of law. And contemporanea expositio et optima et fortuna in lege. The best way to interpret. See, you cannot remember the Latin term, no problem. You can remember the meaning of that. So you should write. Okay. If you can remember the Latin term, it is well and good. These are only two maxims which you have to remember. Therefore, the best interpretation, construction of a statute or any other document is that which has been made by the contemporary authority. Simply stated, old statutes and documents should be interpreted as they would have been at the time when they were enacted, written. Contemporary official statements throwing light on the construction of a statute and statutory instruments made under it have been used as contemporanea expositio to interpret not only ancient but even recent statutes in India. So this is about that. I have seen in multiple papers, you have got the question on usage and customs and practice. So you have to read that and put it accordingly. Let us move ahead. The next one. Okay, here the answer is already given, so you can read it. It is Ayushi and Vipul are good friends pursuing CA course while doing group studies for the paper of corporate and other laws. They are confused about the provision of Section 3 of the Companies Act, which says a company may be formed. So here, whether may will be read as may or may will be read as shall. So here, the word shall is used to raise the presumption of something which is mandatory or imperative, while the word may is used to connote something which is not mandatory but is only directory or enabling. However, some words may has a mandatory force. So here in this case, may is used as a shall. Why? Because the law will never allow the formation of a company with an unlawful object. So here the word may shall be referred as shall. Usage of word may here makes it mandatory for a company for the compliance of Section 3 for its formation. Let us look at another one. When can the preamble be used to aid as an interpretation of a law? So preamble can always be used when there is a confusion with reference to the provision of the act, right? So, but it cannot override the order or enlarge the restrict the enacting the provisions, right? Yeah, preamble is an internal aid to construction. So this much you can write. When will court refer the preamble to aid the construction? There are two situations. One, where there is an ambiguity in the words of an enactment, the assistance of the preamble may be taken to resolve the conflict. Second, where the words of an enactment appear to be too general in scope or application, then courts may resort to the preamble to determine the scope or limit application for which the words are meant, right? This is another example. Without prejudice. So in certain situations, you will have the word without prejudice as harmonious aid to interpretation of statutes. Support your answer with an example. So you see, without prejudice, when certain particular provisions follow certain provisions, and when it is stated that the particular provision are without prejudice to those general provisions, the particular provisions would not restrict or limit the operation and generality of the preceding general provisions. In other words, the particular provisions shall operate in addition to or not in derogation of the general provisions. So here you can see in example of Section 4.3 of the Companies Act, without prejudice to the provisions of subsection 2, a company shall not be registered with a name which contains so and so. So here what it implies? It implies that registering and deciding the name of a company, provisions of Section 4.2 shall be operative, shall also be operative. So this is what I had for you people, and I would be happy to take any further questions on the chat box. Yes. Give me a second. Let me unshare it. Yeah, statutes are to be interpreted as per the usage or prevalent customs. Yes, Ms. Tiwari, you are right. Questions, any questions or any clarifications or any points you want to make, I will be happy to take them up. Yeah. Let me check it from the admin panel if there are any questions. Yeah, Santosh, thank you. Have a great day. Do we have any questions? Uh, um, See, the versus case laws, I don't think that you are required to remember. But situations you can remember. And if there are some examples which are asked, you can give the examples. Like, for example, interpretation of preamble, or just have one examples each. I give you Noscitur sociis or Ejusdem generis. So you can prepare like that. So a simple meaning and one example of that. That much will be sufficient for you. Preparing your own notes will help on these concepts. So I don't think there are more than 10 or 15 concepts which are there in both the including General Clauses Act and this. You prepare concept wise, it will be easier for you to understand. Like for example, repeal of enactments. That is one of the provision. Generally, there will be a question on that. So you can put there. Definition clause, you can put that. Preamble, you can put that. Customs, you can have a look at it. Ejusdem generis, you can have a look at it. Like this, you should prepare each of these particular points, a brief meaning of that, and one example. So even if there is a situation-based question, you will be able to understand and quickly respond. And if it is a short answer question, then also you are able to understand. I'm sharing these particular slides in your admin portal. So I hope you are getting all these particular material. If not, then kindly get in touch with your coordinator. I will be sharing these particular slides on email also with the coordinator, so you can get a copy through them. Okay. So if you people don't have any questions, we can call it for a day. Thank you, everyone. So this concludes our, unit chapter 2, 2 sessions on General Clauses Act and 2 sessions on interpretation of statutes. All the best for your, remaining studies, and look forward to see you soon in some of the other sessions. Thank you. You have been a, very patient and good audience, and you have asked many questions, and I'm happy that you are able to follow what I was trying to tell. I understand that it was a bit of a verbose, a lot of words I had to speak, but you can understand the law is like that, so you have to grapple with it and read them. And probably the similar kind of a situation is with me when I read finance or financial document. Probably you will find it easier for reading financial documents, but similar kind of a situation is there for a lawyer when he is posed or she is posed with the balance sheet and those kind of a document. So it is a vice versa situation. So now you people have to read the laws, because I think as a CA you are required to read some basic laws and familiar with it. And most of the times, if there are some court decisions and Finance Act every year, so that you have to make sense out of it. So it is very important for you to understand this interpretation and General Clauses Act. Yeah. Yes. Anybody else? I think that's it. Thank you, everyone. Then technical team, now you can close the session. Thank you.